We got about 40 seconds, so if you got like last few bits of conversation you want to have, have at it. If you can recite a sonnet in like 30 seconds, I don't know, do that. Count your favorite number, 1 through 20. You got any sonnets you got off the top of your head? Second would be no. All right, here we go. Okay, everyone. Hopefully that last bit of that conversation was worth it. Worth the air you breathed. Hope all your conversations going forward are just the same. I see a lot of you actually did print out the notes, so very good on you for that. But just in order to keep you on your toes, we've actually completely switched the order in which we're going to give these presentations. So all those notes you've got, go ahead and keep till Wednesday. You're still going to need them. They're still going to be the same exact notes. It's just today you're actually going to be learning a little bit about technical communication. I apologize for anyone that got raring to go on that one. I'm a bit of a... These things happen. But the first part of those notes are still relevant. So a note on your projects, I'm going to try to keep your mind focused on those as we go forward. While I was paying attention in the discussion sections to the ways you all kind of decided to talk to one another, which was essentially, I'll email you or you text me, or oh, we've all got iPhones, that's pretty convenient. And while that's all good, don't be afraid to try a few other collaborative tools out there. I mean, there are hundreds. There's a few standard ones that you're probably all familiar with. The last thing you need is an old fogey like me telling you the hot new things in internet technology, but Office 365, the internet connected version of Word, Excel, PowerPoint, they're all pretty good ways of communicating and keeping in touch with each other and working on documents together. Same thing with the Google Suite. In fact, because this university uses Google, that could be a pretty good way of interfacing a lot of things that you might need to. GChat, Hangouts, but now they got like Allo and Duo and God knows what else. And Dropbox is just another good one, especially if you don't have it. There's usually a little university, like, get involved university-wise, and everyone's kind of Dropbox expands, so you can participate in that. You can actually use 2 email accounts, your personal one and the education one. Also, there's a few other ways of doing communication beyond just texting and emailing. And this is going to become especially important once you get into industry. There's a lot of sort of stock standard ways that are coming to prominence in industry. Things like Slack, Trello, and HipChat. Actually, HipChat is now Stride. It looks like Atlassian changed that to Stride just last week. These are great asynchronous ways of communicating. They're ways of collating documents, of making sure you're all working on things, assigning to-do lists, interfacing with tons of other things. So if you've got like an Evernote account or Dropbox, you can put them all in the same place and you can all kind of get together. One of the nice things about these are they're also auditable. You can go back through your communications and hold people accountable and responsible in ways that, having text messages and emails, you sometimes can't. Things get lost in the email, unfortunately. So, don't be afraid to check these out as a group and just see what might work for you. Especially, if it comes time for you all to start interviewing at career fairs, and you can say you've already worked on a project using, well, now Stride, but HipChat, Bitbucket, GitHub. This actually goes a long way towards showing that you are capable of doing the job of an engineer. So now what I want to do is go over that play nice letter I told you all to bring back to class. Is there anyone who just doesn't have it? And that's okay to admit. Yeah, that's fine. We got a couple, 2, 3, so there's one for you. There's one for you. Okay. Anyone else think they need one? A couple that way? All right. All right, actually what I'm going to do is just pass out a whole stack of them. If you find that you don't have one, take one. If you do have it, just keep passing it the other way. Yeah, but just... Okay, and you don't need to keep your hands up if they are going through. one of the things I actually want to do, how many, just complete show of hands, be honest, only you will know in the quiet of your heart if you are lying right now. How many of you actually read just about every single word on this piece of paper? All right, we got about a third. Who did some skimming? Did some skimming. Who just frankly didn't look at it at all beyond, it may have said inventorship somewhere. All right, we got one over there, 2, 3. It's okay. You're engineers. I don't expect you to read legal documents, except that I actually do expect you to read them. And because of that, we're all going to read it here in class together. So dear participant, thank you for electing to participate in Engineering 100, Section 500. This letter lays out how the participants in this class agree to handle issues concerning intellectual property conceived in this class, henceforth known as Class IP. In particular, this letter addresses 4 things. General information concerning the determination of inventorship, handling of Class IP jointly or invented solely by students, handling of Class IP jointly invented by faculty and students, and developing Class IP after the conclusion of this course. By signing this letter, you agree that Class IP will be governed by these terms unless all parties involved expressly agree in writing to an alternative arrangement. Now, of those people that read it, skimmed it, didn't look at it at all, and having just this as your basis, do you have any questions right now about what this document entails? It's okay if you don't. Questions, comments, concerns. All right, way in the back there.
What is a Class IP?
What is Class IP? It is defined legally as intellectual property conceived in this class. So intellectual property is somewhat of a nebulous term. This encompasses things like copyrights, trademarks, patents or patent applications, and inventions. This is basically any thought you have in this head that you feel, or that you have in this class in your heads that you feel you would like to commercialize later. That's essentially what Class IP is. All right, any other questions, comments, concerns to this point? All right, that's great. Now, Anna, what I would like you to do is read the next paragraph for us, determining inventorship.
In contrast to naming authors to a scientific paper, which is typically dictated by the discretion of the paper's contributors, patent inventorship is a complicated legal decision made by attorneys. The determination of inventorship is important because incorrectly naming the inventors to a patent may have negative legal consequences. For Class IP, university attorneys will be available to make inventorship determinations when the identity of the inventors is not clear.
All right, clear as mud, right? Does anyone have a good description of what an inventor is in this case? And thank you very much, Anna.
Someone who comes up with a new idea.
Someone who
something or make something. Or
comes up with a new idea, something, and makes something.
like on how to do something or make something.
All right, sounds good. Thank you, Emily. I got that right?
Yes.
All right. It's already begun, everyone. Any other ways of describing an inventor? Well, good, because that is, Emily's got it almost exactly right. Anyone who conceives of or reduces to practice, or helps in the conception of or reduction to practice of an idea. So that means if you come up with a new widget, a new paperclip, you are an inventor. If you help to make it practically implementable, you are an inventor. If you just help make something, though, if you're just a manufacturer who's stamping out 1 million paperclips, you are not an inventor. So that's one of the key distinctions here. Just because you yourself made it physically with your hands does not necessarily mean legally you are an inventor. All right, just thought I'd point that one out there. Class IP was student and non-university inventors. Would anyone like to read this? You got about 5 seconds before I just start pointing. Danica?
Yes.
All right, fantastic.
Class IP with only student and non-university inventors. Under university policy, students own their inventions, unless the invention was made in the student's capacity as an employee. Whether or not an individual is an inventor of Class IP created by that individual's group will depend on the specific contribution of that individual to the conception of the invention. Not everyone in a particular group will necessarily be a co-inventor of Class IP arising from the activities of that group. Individuals' ownership and use of Class IP owned solely by students and non-university individuals will fall under one of the following scenarios.
Thank you very much. To put that in lay terms, that means if you've got an idea here, it is yours. The university will grant it to you entirely. They just ask a few things of you for that responsibility. And that's actually, I may make that point here. There's a difference between being an inventor on a patent or IP and being an assignee, a person who owns the patent. When you go and work for companies, usually in the piece of paper you sign for being an employee, you sign away your rights to own IP that you develop as a worker in that. Go ahead and read your employee handbooks when you get them, and don't be afraid to argue that language there. If you want to retain some of the IP for your own use, you can go ahead and negotiate that as part of your package. Don't be afraid to delve into the legalistics about it. Okay, who would like to read this next portion? Individuals electing to control their class IP after. All right, Lakita?
Yeah.
All right.
An individual owner or group of student co-owners may elect to control class IP on their own. Such individuals will be solely responsible for the cost of pursuing any patent protection on class IP. In exchange for the use of university resources and/or to allow the university to continue its academic mission, student owners of class IP hereby grant the university a non-exclusive royalty-free license to use the class IP for research, public service, internal, including clinical, and/or educational purposes, and the right to grant the same limited rights to other non-private research institutions.
Thank you very much. Does anyone have a simpler way of putting that? Emily?
I think what it basically means is that if the students decide they want to retain like the complete ownership of the IP, because we kind of came up with this idea at University of Michigan and used their resources to make it more available, or basically would say it's our idea, we get the rights to own the patent, but you can use it more or less for free.
That is a great way of putting it. Yes, entirely right. The idea is yours. If you decide to control it, you are going to pay to get the patent made or drafted, prosecuted, litigated. The onus is going to be on you to drive that IP forward. But you're going to give the university a non-exclusive, royalty-free license to use it however they want, except for commercialization, except to commercialize a product. So that means the university, for all the ideas you're about to have, you are basically granting the university the right to use them for its academic mission. I'll read this next portion for you. So if you decide individuals assign class IP to the university, this is the typical way things go. An individual owner or group of student co-owners may assign their rights to the university in exchange for being treated as inventors and therefore eligible for royalty sharing. Under the University Technology Transfer Policy, which you can find at that URL there, under this scenario, the students would have the benefit of the Office of Technology Transfer managing and funding any patenting or commercialization efforts. So basically, if you don't want to pay to have everything done, as part of your tuition, as part of the overhead of this institution, the university will do it for you. Or will try to. That doesn't mean you're necessarily granted a patent or a trademark or anything. They just will try on your behalf. All right. We're almost halfway through this document. Who is bored to tears? Be honest, completely honest. No one is. All right, we got one honest person in this. We got two honest, reluctantly honest people. Yeah, this is a little boring. But that's the reason the law is hidden here. They don't necessarily want you to be inspecting it too closely. And this is why, despite your sheer boredom with the topic, we do need to plug through it. It is important. It does affect you. And it's going to affect you for the years to come. When you come up with new ideas, they are going to be subject to many of these same laws. So let's continue. Since this is a big paragraph, I'll take it on my own. Class IP that's developed both with a faculty and a student inventor. And this is, again, typical in this class, though it may not be typical in the classes that follow. The intent of this particular class is that faculty will provide problems they are facing in their research or clinical practices, and students will conceive and develop solutions to these problems. Depending on the nature of the interaction between faculty and students involved in a particular project, however, the faculty's contributions to the conception of the solution may be such that the faculty member is the co-inventor of the class IP along with some students. Now, I'm going to take a break right here. Just because someone points out a problem with something does not mean that they are an inventor in the solution. So if you have a faculty member that says X is a problem and you develop Y as a solution, but they don't develop Y as a solution, they are not a joint inventor. So don't be afraid to stand up for your rights on that. If you have any questions, comments, concerns about that, you can always reach out to our Office of Tech Transfer. In this situation where, however, faculty and students are joint inventors, the university and the students may be co-owners of the class IP because faculty typically have obligations to assign their IP created in the course of their research as a university employee. As employees, they do have an obligation to assign their rights to the university. The Office of Tech Transfer will manage the university's interest in the class IP, including deciding whether or how to pursue patent protection, marketing the IP, and any licensing of the IP. Accordingly, the following scenarios are available in situations involving class IP co-owned by the university and one or more students. Now, this next bit is actually the most interesting part of the whole class IP business. Who would like to read it? All right, way in back. Remind me of your name?
Alex.
Alex Sunshine. All right, great.
Patent law, each owner may separately manage their IP, and neither co-owner has any obligation to share any proceeds to the other owner. As a practical matter, however, it is easier to commercialize an invention if the rights are packaged together, and therefore it is typically best for the technology that university and students agree on how to proceed with commercializing the class IP. The two following scenarios present the most likely options for commercializing co-owned class IP, although other scenarios are possible.
The one thing I want to, thank you very much, Alec. The one thing I want to point out here is if you are joint inventors and joint co-owners of some particular IP, the university is going to defend its own interests. So if you want to, say, make a company out of the IP you develop here, and you jointly own it with the university, you're going to need to make a decision about whether or not that is in your financial, legal, and entrepreneurial interest. You may want to own your IP outright. Or you may want to own it with the university. But if the university owns it, they don't necessarily care about your company, your ideas. They care about what matters to the university. So again, always be aware of your rights and responsibilities when it comes to this. Okay, so of the two options that sort of typically follow, who would like to read the first? B. All right, over here, what's your name?
Hamza.
Hamza?
Yep.
Hamza will lead us on B.
The student inventors may assign their rights to the university in exchange for being treated as inventors, and therefore be eligible for royalty sharing. Under the University Technology Transfer Policy, (URL), under this scenario, the students would have the benefits of the Office of Technology Transfer managing and funding any patent or commercialization efforts.
Thank you very much, Hamza. So what you can do, if you just don't really care too much about making a business, or you don't have a business interest in it, assign it to the university. They'll take on all the patent prosecution costs, they'll draft it for you, and they'll try to make sure that you get a good deal with whatever royalties might be due to you. A lot of students do this, and you do end up making some pocket change maybe at the end if it gets licensed. So that's one scenario. The other scenario, scenario C, is going to be read by, over here. Oh, you got to tell me your name.
Oh, Tyler.
Tyler.
The university assigns to students. The Office of Technology Transfer decides against pursuing commercializing the class IP on behalf of the university. The university may assign its ownership interest to student inventors, so that student inventors may continue to pursue commercialization efforts. In this situation, the student inventor agrees to grant the university a non-exclusive, royalty-free license to use the class IP for research, public service, internal, including clinical, and/or educational purposes, and the right to grant the same limited rights to other nonprofit research institutions.
Thank you very much. And that should strike you as familiar. We had just read much of that same verbiage earlier. This is the case where the university assigns you your rights exclusively, or you as the owner of the IP own it exclusively. But you grant to them a license to use it however they want. This is pretty typical of academic relationships. So we won't belabor the point. In any event, if multiple parties share ownership in class IP, whether between students and faculty members or other non-university entity, for example, either because the faculty member was working outside of his or her employment when co-inventing class IP or was not employed by the university, the parties may, 1, choose to separately manage their IP, or more ideally agree on how to co-manage their IP. 2, either party could assign their co-ownership interest to the other, or 3, any non-university individual may consult with the Office of Tech Transfer concerning assigning class IP to the university in order to be treated under the university's tech transfer policy as described above. And I'll go ahead and blow through this section for us. Actually, this might be fun. I'm going to give you about a minute to try to read this on your own. And if you have any questions about it, pop up. But do try to actually read it. For those of you especially that have not read this before, read it and see if you understand what it's saying. I see sort of a quorum of the ayes going up. If you're still reading it, do please continue. Just tune me out for a little bit here. Does anyone have a good summary, just a short, pithy description of what this means? Anita?
So I think it means like after completing this course, if there are students that are inventors or co-inventors of it, if a student decides to decline developing it after the course, then they like assign their rights in the class IP to the people who are continuing it. And for the people that are continuing it, they'll have to share the cost of getting patent protection on the class IP, and whoever declines to contributing to the cost will like assign their rights of the class IP also. But those people who decline all of these rights and assign their rights to other people, they'll still be put as the inventors.
Fantastic. That's some excellent nutshelling there. Yeah, it basically means if you aren't in it to win it, if you don't have buy-in on this, by signing this piece of paper, you are assigning your rights to your co-inventors. If you don't want to move the class IP forward, you'll still be listed as an inventor. You'll still get the contribution that you are owed, but you will not have the patent rights. You will not own any patents, trademarks, copyrights therefrom. Okay, if you now feel comfortable, as if you have understood, oh, I should also say everything that just got set up here and by you all cannot be construed as legal advice. If you would like some, do please go to the Office of Tech Transfer. But if you do feel comfortable, go ahead and sign this piece of paper. One neat little trick you can do if you just want to have a little bit of an old lawyer's trick here is to do a date with your leading zeros so as to not be mistaken for what that date might be, to list your, the full day, full month, and the full year. That way, if you get a scenario where you sign it on January 1st, 2017, I guess, you can't then, therefore, come up and, put something in between. This is for your own protection. Yes?
If you decline to continue with development and you have the rights, would you still be eligible for royalty sharing?
If you are a co-inventor, yes. Unless the parties agree to something different. Yes?
Also, how would you prove inventorship? You said that you would the university attorneys, but if you were a co-inventor with a university member, how could you be sure the university attorneys would not favor
So that is a great concern to have. The Office of Tech Transfer really, in general, the Office of Tech Transfer is not out to screw you. They're going to try to get you all the rights you're owed. They're basically going to ask you, what did you do? Did you conceive of this? What are your contributions? point to where on this description you made a contribution, and they'll believe you. If you're a co-inventor, boom, it's done, easy peasy. If for whatever reason you don't trust the university to be representing your interests, that's when you hire outside counsel or do try to represent your own interests. But again, you don't need to get too worried about that. OTT is here to have all of you flourish, because if you do, the university itself flourishes. But that's a great question. Any last minute one? Okay, we got one back here. Yeah, I wondered why that was there too. This was from, you can put student, you can put grandmaster, I don't know, DJ Jazzy Jeff, just probably student is fine. Engineer and training, that's a fantastic thing to put there. That's another good one. I myself put lecturer. Okay, and if you signed it, go ahead and pass it all the way over here. We'll collect that here from you in a bit. I'm going to make one last plug. This Tuesday, I've actually got this little bioethics discussion group. If you do have some interest in it, it'll be in Laurie Biomedical Engineering in 2185. If, however, you don't give one whit about bioethics and instead believe that you should learn some of the basics of biology, say you haven't taken it in a while, or you're just looking for a refresher, both on Tuesday and Wednesday night at 7 p.m. in 1017 Dow and 1200 Eeks, respectively. Dr. S will be giving a quick overview about the sort of biology you're going to need to be effective in this class. Now we're going to take about a 2, 3, 4 minute break. Let's see, what time is it? It's 1:36. Come back at 5 minute break. Come back at 1:40 if you need to use the restroom, get a drink. Go ahead and do that. But then we're going to turn it over to Dr. S, who's going to go over some more stuff for you. Thank you very much.